Did you know that a handful of courtroom battles turned what engineers thought was free data for training into a legal labyrinth that changed how AI gets fed and how creators get paid? Welcome to Unboxed Origins. I'm Howie, your resident science geek and accidental trivia sponge.
And I'm Wyatt. I ask the big questions. Sometimes philosophical, often skeptical, always curious.
Today we're digging into how did court rulings on AI training data reshape copyright law? Let's step back. For years, machine learning teams treated the internet like an all-you-can-eat buffet. Books, images, code, music, bulk copied, shuffled, and used to train models that then produce text, pictures, and songs. Early legal landmarks set some expectations. The Authors Guild v. Google Books decision in 2015 gave a big hint. Copying works to enable a search function and displaying small snippets could be fair use. That case wasn't about AI per se, but it established that copying for a new, non-expressive purpose, like indexing, could sometimes dodge copyright liability. For developers, that was reassuring. Bulk copying for non-public, back-end processing might be safe. That mindset helped enable a generation of training practices where scale felt like safety. Then the software stack got a jurisprudential jolt. In 2021, the US Supreme Court decided Google v. Oracle. At issue, copying chunks of API-declaring code to allow reimplementation. The court concluded that Google's use could be fair use, emphasizing the different purpose and function of the copied code in creating a new platform. Suddenly, AI coders pointed to this ruling when building models that ingest and reproduce code. Maybe reusing interface like text or snippets is allowed if the new tool has a different purpose. Meanwhile, the US Copyright Office and other authorities began clarifying that works produced entirely by machines without demonstrated human authorship are not eligible for traditional copyright protection. Those two threads, the potential for fair use on back-end copying and skepticism about AI-only authorship, created a paradoxical legal landscape for training data.
Aha! Here's the twist most people missed. While some courts seemed to say bulk copying for a new technical purpose can be fair, other rulings pulled the rug out from under the transformative defense. Take the Supreme Court's Warhol versus Goldsmith decision in 2023. The court tightened the definition of transformation for visual art, ruling that simply changing style or medium doesn't automatically clear you under fair use. In plain English, checking someone's photo and making it artier doesn't necessarily let you off the hook. So, you've got one line of cases gently nodding to back-end copying for technical reasons, and another that tells artists don't count on a broad transformative shield. That contradiction left many judges, creators, and engineers asking, is training a model transformative or just wholesale copying with a shiny new wrapper?
That juridical tension fed a wave of lawsuits aimed directly at AI training practices. Publishers, photographers, stock agencies, musicians, and authors brought suits alleging that companies trained models on copyrighted catalogs without permission. Plaintiffs argued the models didn't merely index, they ingested verbatim or near verbatim content, then reproduced it or produced outputs strikingly similar to the originals. Defendants leaned on precedents like Google Books and Google v. Oracle, arguing many training uses were fair or otherwise non-infringing. The results were mixed. Some courts granted narrow protections in certain contexts, others issued rulings or preliminary injunctions that tightened the noose. Regardless of the legal fine print, the litigation created immediate practical effects. Companies faced discovery orders, potential damages, and reputational risk. That combination forced industry actors to pivot faster than a penguin trying salsa. Industry reaction was both technical and commercial. Technically, teams began to alter training pipelines, more aggressive filtering of copyrighted content, curated clean room datasets, where rights were verified, and synthetic data augmentation, where generated examples replace real copyrighted inputs. companies started adding provenance layers, metadata, and dataset receipts that trace where training items came from. Because courts and plaintiffs wanted to see what was used. Commercially, platforms moved toward licensing. Stock image agencies and publishers began offering training licenses or threatening to. Data brokers cropped up promising license-cleared corpora. Some companies experimented with opt-in programs where creators could receive payment or a share of downstream model profits if they allowed their work to be used for training. In short, the market began saying, if you want our data, write a check or at least sign a contract.
Another aha! These shifts force a new kind of cultural accounting. Copyright law has always balanced creator control with public benefit. Think access to knowledge, or the ability to reuse for parody and critique. But AI training is both massively scalable and opaque. One court's approval of narrow copying for technical ends doesn't easily translate into a social license to vacuum up entire catalogues. So the legal tussles nudged the ecosystem toward contractual solutions. Where law was ambiguous, commerce filled the gap with licenses, takedowns, and business models that reallocate value. It's less copyright law changed overnight, and more practical copyright enforcement and private contracts reshaped how models are trained and monetized.
Ripple effects reached monetization and creative workflows. Platforms that once relied on ad-based distribution began to experiment with revenue-sharing creator APIs and pay-to-train models. Startups emerged offering creator-first model training. Small models trained only on opted-in or paid-for datasets with built-in credit and payout systems. For larger models, companies started to disclose dataset sources more transparently, introduced content filters and watermarking to help creators identify AI outputs, and negotiated licensing deals with large rights holders. Technically, there was also a boom in techniques like fine-tuning on licensed corpora rather than full-scale retraining on scraped data, and the development of inference time constraints that reduce model hallucination of copyrighted passages. All these changes were driven less by a single sweeping ruling than by the accumulation of cases that raised the risks of ignoring creators' rights.
So why should anyone outside law or tech care? Because these court battles and business pivots change who gets paid and how culture is made. If training practices stay unregulated, creators risk losing bargaining power. Their work becomes raw material for models that earn money for platforms. If the industry converts everything into licensable commodities, we might get fewer surprises, but also risk locking up cultural materials behind paywalls. The rulings, settlements, and industry responses collectively nudged us toward a middle path. More transparency, more contracts, and a tenuous new balance between innovation and creators' rights.
Bottom line, court rulings didn't produce one tidy doctrine. Instead, they exposed the edges of fair use and authorship, prompting companies to change engineering practices, publishers and artists to wield contracts and litigation, and the market to invent licensing and monetization schemes where law wasn't yet clear. Engineers rewired their pipelines. Creators negotiated for compensation and attribution. Business models adapted, and policy folks started drafting clearer rules because everyone realized leaving this to a patchwork of lawsuits was an expensive way to set precedent.
It matters because law shapes the incentives for creativity and for technical innovation. When a judge writes an opinion, it influences not just the litigants, but the entire ecosystem. Researchers choose what to train on, companies decide how to price APIs, and artists decide whether to opt in or withhold their work. The present moment is a lesson in how a legal system that can't instantly resolve novel technology often catalyzes industry-led solutions, which then harden into new norms, contracts, and sometimes statutes.
If you're an engineer, a creator, or just someone who likes using clever AI tools, these rulings rewrite the playbook. Expect clearer dataset provenance, more licensing deals, new creator revenue streams, and technical safeguards to avoid reproducing copyrighted content. The legal conversation also signals a longer-term trend, a push for law and tech to co-evolve rather than tech leapfrogging law and hoping for the best.
And if you're a citizen, it's a reminder that copyright isn't just dusty statutes. It's about who gets credit, who gets paid, and who decides what counts as creative labor. Courts have asked hard questions. Industries are answering with contracts and code. And the rest of us get to decide whether that answer is fair.
If you enjoyed this unpacking of precedent, pivots, and policy, like, subscribe, and share to help more people see how legal decisions shape the tech we use every day.
So, how did court rulings on AI training data reshape copyright law? They didn't rewrite it in one stroke. They exposed tensions, nudged industry to invent contractual and technical fixes, and forced a new balance between creative rights and the AI appetite for data.